The cosmetic surgery industry is big and it's growing. It uses all the tricks of the trade to persuade patients to part with their money. Of course, there are plenty of reputable surgeons and businesses in the industry, but there are others with fewer scruples. Surgery is risky. It's a major undertaking not to be entered into lightly. I'm a QC and I've been representing patients who've suffered injury through negligent cosmetic surgery for over 20 years. There's a great deal of information available now for patients considering undergoing cosmetic surgery. You should look at the websites of the General Medical Council, the Department of Health, and the two specialist associations of plastic and aesthetic surgeons, BAAPS and the BAPRAS. But I want to pass on my experience as a clinical negligence lawyer and talk about patients' legal rights. I'm going to look at the 3 C's of cosmetic surgery law: contract, consent, and compensation. A contract is entered when one person makes an offer intending to be bound by it and another person accepts the offer. The bargain is struck. What about cosmetic surgery contracts? You read an advertisement in a magazine by a clinic offering Britain's top surgeons to perform breast augmentation surgery at competitive prices. You answer the advert and you make contact with the clinic that's advertising. Well, the advert is not an offer to enter into a contract. You've not accepted an offer by telephoning or meeting someone from the clinic. The advert is nothing more than a means of attracting your attention and your business. It shouldn't be misleading, but it contains no binding promises. Always look beyond the advert. Don't rely on it. So, you go to a hotel or to a clinic, you meet the clinic's patient coordinator. They, by the way, are not medically qualified. They tell you that they can arrange for you to meet Mr. Wonder, who is their top breast surgeon. The operation will cost £6,000. So if you pay a deposit today, they'll tell you, you can ensure that he will be able to operate on you by the end of the month. So you pay £500 as a deposit. Have you entered a contract? Who with? What for? The clinic will be likely to say that you have not entered into any contract for surgery with them. In my experience, clinics usually argue that all they've agreed to do is to arrange for you to have a consultation with the surgeon. They have not agreed to any surgery at all. They've not agreed that the surgeon will give you reasonable, non-negligent advice. So check, what is the deposit for? Will you get the money back if you do not proceed with the surgery? Who is Dr. Wonder? Look him up on the GMC, that's the General Medical Council Register of Medical Practitioners. It's on the internet. Is he on the specialist register for plastic surgery? If not, ask why not. Is Dr. Wonder employed by the clinic or is he independent of the clinic? How many times has he performed the operation you think you might undergo? Will the clinic be responsible if Dr. Wonder makes a negligent error in advising you or in performing the surgery? Just ask the clinic. Ask lots of questions. If you're unhappy with the answers, go elsewhere. There are lots of providers to choose from after all. You may at this stage be given standard terms and conditions. Read them. They're likely to seek to limit the clinic's liability to you in the event that something goes wrong with the surgery. Take them away and read them before paying a deposit, let alone paying the full amount under the contract. Even if you pay the full fee for the surgery to the clinic, don't assume that the clinic is holding itself out as the provider of all the services you're paying for. You're paying for the use of a hospital, equipment, nursing care, bandages and medicines, the anaesthetist and the surgeon. Who is responsible for the provision of what services? Make sure you clearly understand who is responsible for those services and who would be responsible if something went wrong with each service. Do you have a separate agreement with the surgeon and the clinic, or just one agreement, one contract? So, ask the clinic and ask the surgeon before committing yourself to a contract. Is my contract with you? If something goes wrong, who will be responsible? What exactly am I paying for? And are you insured? A word about insurance. You should be sure that your surgeon has full professional indemnity insurance. Usually this will be with the Medical Defence Union or the Medical Protection Society. But I've had a number of cases where the surgeon lived abroad and visited this country to perform surgery. They had insurance, but not professional indemnity insurance with the MDU or the MPS. Rather, they had insurance with an insurer based abroad, and the insurance was restricted in terms of its cover. When claims were made, the insurer was evasive or simply denied that it had any obligation to cover the surgeon. For example, because the claim was made after the insurance had lapsed, or the surgeon had already had one claim against him that year. So, ask questions about the insurance cover your clinic has and your surgeon has. You do have the right to know. Why not make notes of the answers you're given? If you were very assertive, you could ask the surgeon or the patient coordinator to sign your note of what they have told you. After all, why would they not do so? You have the right of autonomy over your own body. You make choices about the surgery to be performed on you. In a case in 2015 called Montgomery and Lanarkshire, the Supreme Court emphasised that doctors advise, but patients decide. The surgeon has a duty of care to protect your right to autonomy. The surgeon must advise you about the reasonable treatments available and the risks and benefits of them. He must warn you of the material risks. Those are the risks to which a reasonable patient would attach significance, or to which the surgeon ought to know you, the particular patient in front of him, attaches significance. So, let the surgeon know exactly what you want as an outcome of your surgery, what level of risk you're comfortable with. Ask for written information for you to take away and read at your leisure. Do not feel pressurised into going ahead with surgery just because you've already paid money over towards it. You ought to have 2 weeks between the consultation and the surgery, at least 2 weeks, for you to reflect on the advice you've been given. Don't accept a change of surgeon unless you're happy with that change. Ask questions. Only sign notes as accurate if you're sure they're accurate. Why not ask for a copy of the notes the surgeon has made to take away with you as a reminder of the advice he gave you? Make sure you understand that there are alternatives to proceeding with the surgery, including, of course, doing nothing. If cosmetic surgery is negligently performed, or negligent advice has led you to have surgery you would not otherwise have had, you might be entitled to compensation if you've suffered harm as a result. A poor outcome from the surgery, not getting the look you desired, is not necessarily evidence of negligence on the part of the surgeon or anyone else. You would have to prove that, for example, the surgeon used the wrong technique or did something that no responsible body of cosmetic surgeons would support. Disappointment is not proof of negligence. And negligence is not easy to prove, but compensation is only due if there has been negligence. It's much better to make sure in advance of the operation that you have properly qualified, experienced and reputable surgeons, that you know the risks of the procedure, that you understand the alternatives available, and that you know there is no guarantee of a certain result. The object of compensation is to put you back in the position you would have been in had the negligence not occurred. So, if a surgeon negligently fails to do an uplift at the time of inserting breast implants, you might not get your money back. You might instead be entitled to seek compensation for the poor result and the need to undergo a further operation, and something towards the costs, if any, of having that second operation. In some cases, negligent cosmetic surgery has been catastrophic for the patient's health or career. It's been known to cause death. The financial consequences of any injury or death caused by negligent surgery can, of course, be the subject of compensation claims. So, Don't believe the hype. Advertising does not contain contractual promises or guarantees. Make sure you know who you're entering into a contract with and what for. If in doubt, ask. Check the surgeon's credentials. Check the clinic and the surgeon's insurance position and note what you're told. Let the surgeon know exactly what you desire from the surgery. Make sure you understand the alternatives and the risks and benefits of the choices available to you. Take time to consider the advice before making a decision to proceed. If something does go wrong, you will have to prove negligence. You're not entitled to compensation as of right. I hope you found the help you need. Thank you for listening.